Yes, sir.
Good evening, everybody. A very warm welcome to the this program on Code of Ethics titled it's a part of the series Back to the Basics for Code of Ethics. And today we have a very interesting topic. We will be discussing the code of ethics requirement related to direct, indirect solicitation of work, advertisements, use of letterheads, visiting cards, newsletters, websites, social media used by CA firms and members in practice. These are things which affect us on a day-to-day basis in our practice, and it is sometimes very easy to go wrong on in very, very small matters, but which sometimes can land us in serious trouble. So it's very necessary to be mindful of the issues and the restrictions which are or what is permitted and what is not permitted. So we'll first, before we start the program, we will first start with our ICA Mishra ji.
य एष सुप्तेषु जाग्रति य एष सुप्तेषु जाग्रति कामं 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 कामपुरुषो पुरुषो निर्विमाणः निर्विमाणः तदेव शुक्रं तद्ब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यति कश्चन एतद्द्वैता 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 एतद्द्वैता.
Thank you. So coming back to the topic, so code of ethics is, I think, area which not a lot of us tend to take seriously because it's something in the back of our mind, but not, we don't keep it on the first priority. But with the increasing expectation of the regulators, and yes, we need to be more and more aware, and that's where at WRC we have thought that we will be, we'll try our best to create as much awareness as possible about the code of ethics amongst our members. And as a part of this monthly series of, we'll be having a 2-hour program every month. In addition to that, what we are also planning to hold specific areas under the code of ethics committee, where we will be trying to assist the members to ensure that they have awareness and also they can more easily comply with the code of ethics requirements. We are very soon launching a monthly video which will be covering various FAQs related to code of ethics. So I hope our members are able to take benefit of this. So coming back to today's program, we have with us a very expert faculty, a very senior person whom we consider as the foremost expert on code of ethics, CA Shashikant Barve sir. And we also have CA Murtuza Kachwala sir, who is the chairman of WRC, is the inspiration behind this series. So first, I would request Murtuza sir to kindly address the audience and also lay out his vision.
Thank you, Rahul bhai. Very warm good evening to all the participants. And I was just checking with the backend team. There are more than 200 registrations, and we can already see 135 people online. So really, see, ultimately conducting programs, you get the satisfaction only when there are participants, and like with 200 people joining, the faculty also, it is worth its time, and it is like really a happy moment for the organizers. So let me first thank Shashikant Barve sir, extremely grateful and for accepting our invitation and joining us today and sharing your valuable knowledge. Barve sir is like an expert and on ethics, and like I would say he's an encyclopedia. You can ask him anything and he can give you the answer directly, and he may be even able to tell you the section, like what is written where. So, sir, grateful. Let me thank the chairman of this committee, Rahul Parekh, for taking lead and doing so much. And like every month, we are going to do at least not one, but more than one program. And Rahul is also creating videos on ethics now. He will start to create every month. And we are going to sit with Barve sir and chalk out a calendar for continuous programs throughout the year. So a lot of action should happen here. Let me also recognize presence of Ketan Siyya, Regional Council members, and Vikasa Chairman. He is with me in the room here. And so like to all the participants, friends, on a regular basis, so many people call up and say like, what color can I use on my visiting card? Can we use red and green color, or can we print something like this? Can I put my office address, or can I not put my this? Or can I put my office address and residential address? And X and Y. There are so many things. Similarly, should I put a neon sign board outside my office or not? Can I put a brochure? Can I prepare a pamphlet and put a newspaper? And some people go and write on digital media, like filing of return in 1,000 rupees or 100 rupees or 500 rupees and doing this or doing that, whether that is allowed or not allowed. So when we talk about only today's subject, from printing of letterhead to visiting card to envelope, there are so many things which we need to take care of in a regular life. So this is one aspect of it which we are covering. But in this series, we're going to cover multiple different type of aspects. Like if I send a letter when I'm appointed a new auditor, and I send a no opposition letter to my predecessor and he does not reply, then how many days should I wait and what should I do? What is my risk if I accept and he does not give me the NOC? So I'm saying there are so many small things. And now with the revision of the code of ethics, again, it is that much more important for us to do a complete revision and walkthrough. And hence there are so many things which we are planning. So really grateful. And to the participants, let me tell you, there is no need to write your membership number in the chat box. While you did the registration, you given us the membership number, CP will be accordingly credited to all the members who attend today. So don't need to write there. In fact, I would request everyone to please type as many questions as possible in the chat box, so that towards the end, the coordinators can read out the questions to Barve sir, and Barve sir will be able to provide answers to all of us. So with that, happy learning to everyone. And over to you again, Rahul bhai. Thank you. Thank you.
Thank you very much. Ketan bhai, welcome. Now I just take this opportunity to as such, Barve sir needs no introduction, but I'll just formally introduce Barve sir. So Barve sir is a fellow chartered accountant of our institute and a very senior member. He was a central council member for the term 1997-2000. He has also been the part of the WRC, the Western India Regional Council, for 6 years from 1991 to 97. He was the chairman of Pune branch in 85-86 and has been the managing committee member of Pune branch for 6 years. Barve sir has delivered a lot of lectures, and as we consider him as a guru in code of ethics, and he has helped many members in representing their cases before the ICR disciplinary directorate at New Delhi. So with these few words, I welcome Shashikant Barve sir to this today's program. And sir, again, a very big thank you for accepting our invitation. So I welcome sir. Sir, you can now start. The floor is yours, sir.
How can I share the presentation, please?
Sir, there is a...
Sir, they will make you co-host and they will allow you to share. Mishra ji?
Sir, allowed किया है sir को मैंने.
Sir, yeah.
Yes, sir.
Sir, your presentation is now visible.
Okay. Good afternoon, everybody. Thank you for the kind introduction. I'm not an expert on the subject, but because I had helped many members in representing their cases before the disciplinary authorities, I could read a little bit more. So I would be sharing my views or whatever I could read on this particular topic. but every member should read the act, the regulations, and the code of conduct for the better understanding of the subject. The today's topic covers the basics of code of conduct and the topic relating to soliciting the clients and professional work and advertisement of the professional attainments and services. That is the clause number 6 and clause number 7 of part 1 of the first schedule to the Chartered Accountants Act. It's a human tendency to look to those clauses or sections more carefully where the contraventions are punishable. Therefore, we would start with the certain aspects relating to the code of ethics, its importance, its development, and what are the contraventions of the code of ethics in relation to clause 6 and clause 7. Similarly, we will see the important sections of the act like section 7, section 21, section 22, and the various clauses in the first schedule and the second schedule, which are important from the contravention and punishment point of view in respect of clause 6 and clause 7. We would also see what exactly are the wordings of clause 6 and clause 7, and we would also look to the various explanations in respect of the terms used in these both clauses. We would also see the various situations in which the advertisement would be permissible. So broadly, the canvassing and the advertising is prohibited and is treated as unethical. But we would find out certain provisions whereby leverage has been given to advertise the services in certain situations in certain specific manner. We would also see certain clarifications issued by the Ethical Standard Board of ICAI, and we would also see some cases which have been decided on this subject. I have tried to compile the various situations in which the clauses would get attracted and what care the member should take in those situations. So we would start with certain basic concepts of the code of ethics, which would be relevant from the point of view of clause 6 and clause 7. See, ethics is not something new to us. Ethics has been taught to us from our childhood. Our parents have always told us that speak the truth, that is the concept of integrity. They have also told us whatever we do, we should do it with full care and by putting in full efforts. That is exactly the fundamental principle of the professional competence and due care. They have also told us that we should go on learning new things and new subjects in life. That is exactly the continuing professional education. And lastly, they always used to tell us, don't indulge into wrongful conduct. And that is exactly the concept of professional and other misconduct. So ethics is known to us right from our childhood. So if we are in a dilemma, we should consult our heart and our conscience, and we would really get the right answer. Ethics means the moral values in the human conduct, and it's something which comes from within of an individual. As far as professionals are concerned, the overriding motto should always be the pride of service in preference to the personal gains. Now, ethical values and legal principles are related, but ethical obligations in many cases exceed the legal duties. So there might be certain cases where legally certain actions are permissible, but ethically they may not be right. So we should follow the ethical values rather than giving preference to the legal duties, only legal duties. The business environment, both at national and international level, has been changing, and there have been changes in the expectations of the various stakeholders like the employees, the investors, the government authorities, the tax authorities, business community, and in fact the expectations of society in general. So there is a concept of public interest which has become more important nowadays. Now, what are the practical advantages of code of ethics? So there are two distinct advantages which I could see. One is when there is a self-imposed code of ethics like the one which we have, it gives an assurance to the public that the members would perform their duties properly in the public interest. And if they do not perform their duties properly, there would be some institution who will take such members to task. So that gives an assurance to the prospective clients to give more and more business comfortably. The other important advantage is there are various regulating agencies like ICAI, disciplinary authorities, or NFRA, or RBI, or SEBI. All these agencies are keeping close watch on the reports and certificates issued by the members. And if they find any problem with such reports, they might initiate proceedings for misconduct against the members. In such situations, if the members can display that they have complied with the provisions of code of ethics, in that case, there would be better situation that they may not be held guilty where the proceedings are initiated. The first edition of Code of Ethics, at that time it was known as Code of Conduct. The first edition was published in 1963, and thereafter there have been constant updations based on the changes in the economic environment and the changes in the expectations of the stakeholder. So the latest Code of Ethics has been issued in 2019, and it is based on the International Ethics Standard Board of Accountants Code of Ethics. And because ICI is a member of IFAC, while designing the Code of Ethics this 2019, the appropriate consideration has been given to such international code of ethics. The important aspect is this Code of Ethics 2019 has been issued as a guideline of the council. Now, the importance of issuing the same as guidelines of the council is that it is binding on the members. There is a specific clause in part 2, clause 1 of the second schedule of the act, which says that the contravention of any of the provisions of the act, regulations, or the guidelines of the council is punishable, and therefore it is necessary to follow the code of ethics. The new code of ethics has come into effect from 1st July 2020. There have been 3 volumes. The first volume is based on the principles, or it is a principle based conceptual framework. The second volume consists of the various explanations in respect of all the clauses covered in the first schedule and second schedule, and the volume 3 includes case laws for last more than 50 years on the various clauses. Now, there are certain fundamental principles prescribed in the code of ethics which have to be followed by each member. The principles are integrity, objectivity, professional competence and due care, confidentiality, and most important in the context of the today's subject clause 6 and 7 is professional behavior. Whatever is described in the advertisement or in the representation should be true. That is the concept of integrity. Similarly, the confidential information relating to the clients should not be disclosed in the advertisements or websites or write-ups. That is the principle of confidentiality. And as far as professional behavior is concerned, the member has to comply with all the relevant laws and regulations, and the member should avoid any action which will discredit the profession. So there should not be any activity undertaken by the member which will bring disrepute either to the profession or to the institute. Now, the professional behavior concept includes the concept like there should not be exaggerated claims in the advertisement in respect of either the member's qualifications or experience or in regard to the services rendered by him. Similarly, there should not be unsubstantiated comparisons of his services with the services rendered by other fellow professionals. And there is also a requirement that the member should observe the conditions or the guidelines put in the advertisement guidelines 2008 issued by ICAI while undertaking any activity relating to advertising the services. Now, briefly, there is a disciplinary directorate established by the institute. It is headed by Director Discipline. The authorities are Board of Discipline, Disciplinary Committee, and Appellate Tribunal. The Director Discipline has power to suo motu initiate the proceedings. That is, if he comes across the website or the write-ups containing the material which is against the public policy or which is not in the line with the guidelines of the institute, then he can initiate suo motu the proceeding against such member. There are two schedules to the Chartered Accountants Act, the first schedule and the second schedule. Both these in all 34 clauses, there are various acts and omissions which have been described in these two schedules. The acts and omissions in the first schedule relate normally or in majority cases relate to the actions or the relations between the member and the institute, while the other cases go to the second schedule where the acts and omissions relate to the members' behavior in relation to the outside stakeholders. The seriousness of actions and the omissions in the first schedule are lesser than the actions and omissions mentioned in the second schedule. Obviously, the punishments in respect of the contravention of the first schedule and contravention of second schedule are different. That is, the punishments are lower in the case of contraventions of clauses of first schedule, and the consequences are serious or punishments are serious in respect of the contravention of clauses in the second schedule. The clause 6 and clause 7, they come under the first schedule. The contravention of these clauses comes under the authority of the Board of Discipline. We will not go into the detailed process, but the Board of Discipline has power to take any of these three actions. That is, it can reprimand a member, or it can impose a fine up to 1 lakh of rupees, or it can remove the name of members from the register for a period of 3 months. There are other contraventions like contravention of any of the rules, regulations, or guidelines of the council that comes in the second schedule, and such cases go to disciplinary committee, and there the disciplinary committee can take any of the three actions or all of the three actions. That is, they can reprimand the member, or they can impose fine up to rupees 5 lakhs, or they can even permanently remove the name of the member from the register. There has been a new act, Amendment Act of the Chartered Accountants, Cost Accountants and Company Secretaries Amendment Act 2022, by which many amendments have been brought in respect of the disciplinary mechanism, but that is not the topic for discussion today. We have seen that the contraventions are punishable. We will see the important sections in relation to the clause 6 and clause 7. The first section is the section 7, which mentions that every member of the institute in practice shall, and any other member may, use the designation of a chartered accountant, and no member using such designation shall use any other description, whether in addition thereto or in substitution thereof. Now, we would see here itself the provisions relating to the use of descriptions or the designations. Now, it has been mentioned that nothing contained in this section shall be deemed to prohibit any such person from adding any other description or letters to his name if entitled thereto, to indicate membership of such other institute of accountancy, whether in India or elsewhere, as may be recognized in this behalf by the council, or any other qualification that he may possess, etc., etc. So, what is permissible is, apart from the words chartered accountant, the member can use the words of insolvency professional or registered valuer if he is qualified in those courses or examinations. Similarly, the qualifications of those accounting institutes which have the mutual recognition agreement or memorandum of understanding with ICAI, the qualifications of those accounting institutes can be mentioned. The ICAI diplomas can be mentioned on the cards, but certificate courses, they cannot be mentioned on the cards. Now, what care the member should take that certain types of qualifications or descriptions should not be used on the professional documents. Now, normally, there would be the use of visiting cards or letterheads or signboards or other professional documents. Now, the members should avoid using the description of their directorships in other companies, or membership of political parties, or membership of CA cells in the political parties, or they're holding different positions in various clubs. They cannot write president of a particular club, or member of parliament, or municipal councillor, or they cannot use adjectives like IT lawyer, or GST consultant, or finance consultant, or income tax consultant, or cost accountant, or company secretary, or cost consultant, or management consultant, or corporate lawyer, Now, CPA, meaning Certified Public Accountant, that cannot be used on the cards or the letterheads. So broadly, we have seen what types of qualifications or descriptions can be used and what types of qualifications or descriptions cannot be used either on the visiting cards or letterheads or signboards or other professional documents. We have already seen the director discipline can suo motu initiate proceedings for professional or other misconduct under section 21. Now, section 22 is important, where it has been written that nothing in this section shall be construed to limit or abridge in any way the power confirmed or duty cast on the director discipline under subsection 1 of section 21 to inquire into conduct of any member of the institute under any other circumstances. So, the disciplinary authorities can inquire into the conduct of any member and under any other circumstances. That is, if the member brings disrepute to the institute by his actions undertaken even when he is not doing the professional work, still the disciplinary proceedings can be initiated against him. So there are two important clauses. Clause 1 of part 2 of the second schedule, which says a member of the institute, whether in practice or not, shall be deemed to be guilty of professional misconduct if he contravenes any of the provisions of this act or regulations made thereunder or any guidelines issued by the council. And part 4 of the first schedule, clause 2, it mentions a member of the institute, whether in practice or not, shall be deemed to be guilty of other misconduct if he, in the opinion of the council, brings disrepute to the profession or the institute as a result of his action, whether or not related to his professional work. So, the member should not, or the member's conduct should not be of such a nature which can be described as unbecoming of a professional, or he should not write anything in the write-up or on his website which is against the public policy or which would bring disrepute to the profession. Then the actions can be initiated even under these provisions. Now we come to the specific clauses which are under discussion today. The clause 6 specifically mentions that a chartered accountant in practice shall be deemed to be guilty of professional misconduct if he solicits clients or professional work either directly or indirectly by circular, advertisement, personal communication or interview or by any other means. So words important are directly or indirectly and by any other means, provided that nothing herein contained shall be construed as preventing or prohibiting any chartered accountant from applying or requesting for or inviting or securing professional work from another chartered accountant in practice, and a member from responding to tenders or inquiries issued by various users of professional services or organizations from time to time and securing professional work as a consequence. So what is permitted is a chartered accountant can request another chartered accountant in practice for professional work, maybe on as a salaried employee or on contract basis or on partnership basis, and he can issue such advertisements in the newsletters or the journal of the institute. There are specific guidelines about how to respond to the tender. So there are tendering guidelines which we would see little later. So it is permitted to respond to tenders under certain situations. Now, broadly, the member should not adopt any even indirect methods to advertise their professional practice with a view to gain the publicity and thereby solicit the clients or professional work. Now, why such a restraint is necessary? Such a restraint is necessary so that the members can maintain their independence of judgment and they may be able to command the respect of the prospective clients. It is understood that the work will follow due to the respect that the member commands for his professional talent and skills and by the confidence which he inspires by his reputation. So normally, the all forms of canvassing are treated as unethical and are prohibited. Advertising word has been defined in the Code of Ethics, Volume 1. It says advertising is the communication to the public of information as to services or skills provided by the professional accountants in public practice with a view to procuring professional business. Very clear definition or description. The word solicit has not been defined in the Code of Ethics, but normally, as per dictionary, the word to solicit normally means to make a request or to make an application or to make a petition or to urge strongly to another person asking for business or asking for support or asking for help. The next clause, first we will see the wordings of these two clauses and then we would see various situations in which the clauses would be applicable and what care can be taken by the members. Clause 7 says, a chartered accountant in practice shall be deemed to be guilty of professional misconduct if he advertises his professional attainments or services or uses any designations or expressions other than chartered accountant on professional documents, visiting cards, letterheads, or signboards, unless it be a degree of university established by law in India or recognized by the central government or a title indicating membership of the ICAI or any other institution that has been recognized by the central government or may be recognized by the council, provided that a member in practice may advertise through a write-up setting out the services provided by him or his firm and particulars of his firm, subject to such guidelines as may be issued by the council. Now, the wordings are important. If he advertises his professional attainments or services or uses any designation or expression other than chartered accountant on the professional documents, visiting cards, etc. We have seen earlier what sort of designations can be used, what sort of designations cannot be used. And here it is mentioned that the professional attainments cannot be advertised. So even though generally the advertisement for procuring the business or for soliciting the clients is not permissible, there is a major solution or there is a major concession given in the clause 7 itself now, which says that a member in practice may advertise through a write-up setting out the services provided by him or his firm and particulars of his firm, subject to certain guidelines. Now, this is a very important way out which can be used by the members to advertise their services and the particulars of their firm. Now, we will see the description of the word write-up. Write-up means the writing of particulars according to the information given in the guidelines setting out services rendered by the members or firms, and any writing or display of particulars of members in practice or of firms issued, circulated, or published by way of print or electronic mode or otherwise, including in newspapers, journals, magazines, and websites in push as well as in pull mode in accordance with the guidelines. The only restriction is the write-up has to be presented in a manner to maintain the profession's good reputation, dignity, and its ability to serve the public interest. Now, if we look to this description of write-up, it covers various aspects. It covers that you can advertise your services, you can advertise the particulars of the members, you can advertise such particulars in the print media or electronic media, in newspapers, in journals, in magazines, and in websites, and in both the modes, the push mode or even the pull mode. Now, there are certain restrictions as far as the write-up is concerned. There are, and these constraints or these limitations are applicable to generally all sorts of advertisements or all sorts of communications made by the members in respect of advertising the services for procuring the clients or the business. Now, the write-ups can include photographs, it can include the services provided, it can include the number of partners, employees. It should not be claiming superiority on other members or firms. It should not be indecent or it should not be sensational. And it should not contain any testimonials or endorsements given by the other persons. Similarly, there should not be exaggerated claims for the services offered or for the qualifications or experience of the members or the partners. Similarly, the write-up should not be of a nature that may bring profession into disrepute. The write-up should not contain any testimonials or endorsement. It must not be violative of any provisions of the Chartered Accountant Acts or regulations or the Code of Ethics. Normally, the font size in the write-up should not exceed 14. The write-up should not contain any information about the achievements or awards or any other position held or any accreditation granted by any organization except awards given by the central or state governments or by regulatory bodies. Monograms of any kind or use of any kind of catchwords is not permissible. It is mandatory to mention the membership number and the FRN on the write-up. Now, one important provision is the ICAI can issue directive for removal or withdrawal of the whole write-up or of any part of the write-up if they come across any objectionable write-up circulated by the member. So, see, these are the provisions which can be used to the advantage by the members. So even though there is a general concept that they are not allowed to advertise, still through this medium of write-up, I think there are lots of opportunities to advertise the services and the particulars of the firm. Now, there are various guidelines or the provisions which need to be looked into by the members, and I have covered various situations mentioned in these guidelines in the presentation. There are advertisement guidelines 2008 which include these write-up. There are website guidelines issued by the council. There are clarifications in respect of restriction on manner of making entries in the directories. There are guidelines for use of CA logo. There are guidelines for responding to tenders. Then there are announcements on use of designations other than chartered accountant, which we have seen. There are announcements for abstaining from sharing of firm details intended for comparison of firms. And there are also announcements in respect of advertising by the members in practice engaged in coaching or teaching activities. In the further part of presentation, I have tried to cover the important aspects from these guidelines or circulars. Now, another important concept is website. So we have seen the provisions relating to write-up. There are also the guidelines in relation to the creation of the website. The chartered accountants the chartered accountants and the chartered accountant firms are free to create their own website. There is no standard format prescribed for the website. Website are to be run on a pull model and not on push model of technology. So there should not be issuance of any circular by virtue of which the member should solicit people to visit this website. The website address can be mentioned on the professional stationery and on emails. Now, certain important aspects can be mentioned in the website, that is the year of establishment, that is how old the firm is, details of partners, details of employees, job vacancies, chat rooms, bulletin boards, professional updates, links to certain other important websites. The such important aspects can be included in the website. The certain aspects have to be maintained only on pull request, that is services rendered, then areas of experience of members and employees, and the nature of assignments handled. These aspects should be provided on pull request, that is whosoever only wants to know about them, he should get those details. Important is the names of the clients and the fees charged should not be given. Of course, except when it is a requirement of the regulator. But otherwise, names of clients and fees charged should not be given in the website. Also, the contents of the website should not amount to soliciting the clients or soliciting the professional work. And there should not be violation of any code of ethics or act or regulations on account of the contents of the website. The firm can provide link of its pages on the social networking sites. However, the member should not solicit people to visit or like their respective pages on such networking site. And most important, no advertisement in the nature of banner or of any other nature would be permitted on the website. Now, these are the important provisions in respect of the designing and operating the websites. There is another important aspect or the concession now given. Appearance of CAs on electronic media now allowed. Members may appear on television, film, and internet and agree to broadcast in the radio or give lectures at forums and may give their names and describe themselves as chartered accountants. Special qualifications or special knowledge directly relevant to the subject matter of the program may be given. Firm name can also be mentioned. However, exaggerated claim of any nature or comparison with other firms is not permissible. Now, whatever would be said in such appearance on the media, that should not be promotional of the member or of his promotional of his firm, but it must be an objective professional view of the topic. So the members can appear on television, film, internet, and on radio and give lectures at forum. They can use the words chartered accountant, they can give the firm names, only with certain restrictions about not making exaggerated claims and not making comparisons with others. So even though there is a general feeling that advertising directly or indirectly is not permissible, we have seen three important aspects: write up where the advertising is permissible, websites where the advertising is permissible, and appearance in even on the internet and other media whereby certain type of advertisement may be possible. Now, there are various situations which I have tried to compile in this presentation, arising out of the various guidelines which I had mentioned earlier. So, the member should not advertise in a manner appearing to solicit the clients or appearing to solicit the work. Such advertisements of soliciting the work should not be made even to a small group of possible clients. No personal canvassing or canvassing for clients of previous employer, that is not permissible. Now, what is permissible? A member may request another CA in practice for professional work. The member can advertise changes in the partnership or dissolution of the firm, or of any change in the address of practice or changes in the telephone numbers, but the restriction is appropriate consideration should be given that only the bare fact is advertised. The area of distribution of that particular newsletter should be seen, and the number of insertions in such a newspaper given should also be appropriately considered. But it's possible to advertise the changes in the partnerships, etc. The member is also permitted to issue classified advertisement in the journal or newsletter of the institute relating to the partnership basis or assignment basis or employment basis, asking for work from other professional chartered accountant. Only thing is he has to give only the factual information about his address, telephone number, etc. Now, there are various panels maintained by various government departments, government companies, corporations, or courts, cooperative societies, or banks, and many other similar institutions. Now, it would not be proper for the practicing chartered accountant to make roving inquiries by applying to any such organization for having his name included in such panel. If he is aware that a particular institution is maintaining a particular type of panel, then he can make inquiries for empanelment for that particular entity for that particular purpose. But no roving inquiries should be made, or no letter should be sent to multiple authorities without even knowing whether and what type of panels they have been maintaining. Similarly, recommendation letter should not be obtained and submitted for securing the work. Most important, undue influence should not be used for getting the work from the proposed clients. Now, there are other situations that practicing as a advocate. Now, ICAI permits the member who is otherwise qualified to work as or to practice as advocate, but this is subject to the permission of the Bar Council. Presently, the Bar Council is not allowing their members to practice also in other areas. But ICAI allows such members to practice, but only restriction is they should not use the word chartered accountant and advocate simultaneously on their visiting cards. Similarly, the practicing as company secretary or the as cost and management accountant, the members in practice who are otherwise eligible, that is, who have passed the examinations of the company secretary institute or cost accounting institutes, they can also practice as company secretaries or cost accountants, but they should not use the designations of these institutions simultaneously with the designations of chartered accountant. Now, when they would be permitted to practice as either the cost accountants or as company secretaries, still they would be treated as members in full-time practice as far as ICAI is concerned. Now, the mention of firm name except on professional documents. So it is expected that the firm name and the word chartered accountants would be used on the professional documents like visiting cards or letterheads or signboards, and not on other documents except in certain situations. Now, there would be certain types of greeting cards or invitations. So the designation of chartered accountant and the name of firm can be used on greeting cards or invitations for marriages and invitations for religious ceremonies or any invitations for opening or inauguration of office of the members or change in the office premises or change in the telephone numbers. So such greeting cards or invitation cards can be issued provided that such greeting cards and invitations are sent only to the client's relatives and friends of the members concerned. Now, there is a situation where there are notices in the press relating to the success of the students in the examinations. So, the notices in respect of the success in the examination can be given, but care should be taken that it should not contain any element of undesirable publicity. It should not look like it is an advertisement for solicitation of either the clients or the solicitation of the professional work. The other aspect is that the members should use letterheads of the firms for issuing reports and certificates. There might be situations where certain reports or certificates issued for certain entities may get circulated to a small group of outsiders. So the extent and manner of publication of certificates are limited to what is necessary to enable the report or certificate to serve its proper purpose. There might be certificates issued, say maybe for the local Ganpati Mandal, or it may be for Devi Puja ceremony. So there might be certain certificates issued for certain purposes to specific entities, but it should be ensured that the circulation on the or reports on the letterheads of the firms, their circulation should be limited to the expected class of the people, and the circulation should get restricted only to the extent it serves the proper purpose of issuing that certificate. There is another situation whereby it is mentioned that a member should not accept the original professional work emanating from a client introduced to him by another member. So some another member might have introduced a particular client for a specific work to the member. So if any original new work is brought by such an introduced client, in that situation, the member should request that client first to go to the original member who had directed that client to come to the member, and he should not accept the original professional work. Now, another situation may arise where the auditor gets a right to make representation to the shareholders when it is proposed to pass a resolution of appointing another statutory auditor or not appointing the existing statutory auditor. So when such a right of making a representation is obtained by the member, still he should take care that when he makes the representation, the wording of the representation should be such that the opportunity should not be abused to secure the unnecessary publicity. In the earlier slides, we have seen that a member is permitted, a member in practice is permitted to respond to the tenders in certain situations. So there are tendering guidelines 2016 which have been issued in respect of the tenders issued on or after 7th April 2016. Now, what are the situations in which the responses can be given for the tenders? So if the tenders are for services or areas that are exclusively reserved for the chartered accountants, then the tenders should not be responded unless minimum fees are also prescribed in the tender. So a response to the tender can be given in case of services or areas which are exclusively reserved for the chartered accountants, mentioning the minimum fees in the tender itself. Obviously, the minimum fees should be of such a nature that they should be reasonable from the point of view of the time required to be spent and the complexity of the job involved. Now, responses to the tenders for services or areas which are open to other professionals along with chartered accountants, in such cases, responses can be given. So, where the services are reserved for exclusively for CAs, the response can be given if only the minimum fees are prescribed. But if the tenders are for such services which are open to other professionals also, in that case, responses can be given, even though minimum fees are not prescribed. Now, there might be cases where these services or areas for the tender are open to CAs and also for other professionals, like say for taxation services. But the tender document also specifies that only CAs should apply. In such cases, the tenders can be responded because they are for areas open to CAs as well as other professionals. Now, if there are requests made by individual letters, by the client inviting quotations from specific members. In that case, responses can be given to such letters inviting quotations. Now, the important provisions are that the members have to maintain a cost sheet in respect of the amount filled in the tender by them, which will support the figure mentioned by them in the tender. And the institute has got right to call for any papers or documents in respect of the bids submitted by the members in response to the tenders. So these are, in nutshell, in short, the provisions contained in the tendering guidelines of 2016. Similarly, there are guidelines for the networks. The guidelines for networks were issued on 2nd September 2011. Now, there have been changes in the networking guidelines. They have not been incorporated in this presentation. But conceptually, the important things in relation to network, important things are that one, the associations with the network as a medium of referral of professional work is permissible only if the network is registered with the ICAI, and secondly, it comprises only of chartered accountants or chartered accountant firms governed by the institute's network guidelines. So, what is important is the members can join the networks where the networks consists of only the chartered accountants, and the networks have to be registered with the institute. The firms constituting the network can use the words network firms on their professional stationery. The members of network may advertise, but subject to the advertisement guidelines issued by the institute, which we have seen earlier. They can also use the words and affiliates after the name of the network. Now, the important area is there are certain application-based service provider aggregators. Now, they invite listing from members, and their websites contains the other categories like technicians, maintenance workers, event organizations, businessmen on their websites. So these are application-based service provider aggregates. Now, it is not permissible for the members to list with such online-based service provider aggregators. This is an important aspect which the members should note. Now, for the convenience of members, the Ethical Standard Board of ICAI has launched and operationalized a CA Connect portal, which is a search engine portal for CA firms and individual CA practitioners on the platform of ICAI. Now, this portal is accessible at the web link I have given in the presentation, https://caconnect.icai.org. So this is a CA Connect portal where the member can register and describe the particulars of his firm and the areas of service, and the prospective users can visit this website and get the information about the members or the firms. There are other important aspects relating to the use of a logo. Now, what is allowed is only the common CA logo. We are aware of the common CA logo, which has been prescribed by ICAI, and the object of common CA logo is to promote the brand of CA profession, and therefore this common CA logo can be used both by the members in practice and also members in service or members otherwise engaged. Now, the important restriction is the use of logo or monogram of any kind, form, style, design, color, whatsoever on any display material or media like paper, stationery, document, visiting card, magnetic devices, internet, signboard by members in practice or the firms is prohibited. So except this common CA logo, no other logo or monogram of any kind is permitted to be used. Similarly, even the use or printing of member's name or firm's name in any other manner which may tantamount to logo or monogram is also prohibited. So these are important aspects which needed to be kept in mind. Now, there are other announcements or advisories issued from time to time. One such advisory issued in April 20 in respect of mentioning fees on advertisement issued by the members. It clarifies that quantum of fees, including free of charge services, should not be mentioned by the members in any advertisement of services or posting of particulars. This came up in the time of pandemics, where it was found that the services are being described by members either as free of cost services or services at concessional rates, and probably in view of that, this clarification has been issued that the quantum of fees, including free of charge services, cannot be advertised. There is another situation where certain entities may ask for details of the chartered accountant firms for the purpose of making the ranking of those firms through comparison on different parameters. Now, sharing of details of the firms for such purpose is not allowed because sharing of such details would or is likely ultimately to result in claiming superiority by one firm over the other firm. So, information should not be provided to such entities who are involved in ranking of CA firms. Now, two other aspects which are important and which should be noted is the description, like firm established since year so and so. This should not be mentioned on the professional stationery. The date of establishment, like the seniority, so it cannot be mentioned on the professional stationery. Similarly, it is not permissible to print the vision and values on the visiting cards, because that would or that may result in the solicitation of clients or professional work. This is a clarification issue which is important and which needs to be noted by the members. Now, there are other situations like sponsorship of an event. So, sponsorship by the members, practicing members, or by the firms for any event is normally not permitted. This is permitted only in respect of a CPE event organized by a program organizing unit of ICAI, provided it has prior approval of the CPE Directorate. Sponsorship, there may be cases where sponsorship of activities relating to CSR, corporate social responsibility nature. Now, members can sponsor such activities relating to CSR activities, and they can mention their individual name with prefix of CA. However, the firm name cannot be used, or the CA logo is not permitted to be used in such case. The other normal situation which we come across is there is uploading of educational videos. Now, educational videos may be uploaded by the members. However, no reference should be made to the CA firm, wherein he may be a partner or proprietor. And it should not contain any contact details or the website address. So, uploading of educational videos is permissible with these restrictions. Now, there is an announcement on 18th May 2017, which is applicable to members who are involved in the activities relating to teaching or coaching. By this announcement, the members are advised to abstain, such members who are involved in the coaching or teaching activities, such members are advised to abstain from advertising their association with the coaching or teaching activities through hoarding, posters, banners, and by any other means. However, such members may put outside their coaching or teaching premises a signboard mentioning the name of coaching institute and their contact details and the subject taught therein. So this relates to the members involved in the teaching or coaching activities. So they should not advertise their association with such activities through the posters, banners, etc. Now, there would be cases where there would be TV or movie credits. So the member or firm name is allowed to appear in TV or movie credits. However, it should not be mentioned differently from the other persons mentioned in that advertisement. Now, there might be cases where the members or firms publishing advertisements under box numbers. Now, members or firms are not permitted for inserting advertisements for soliciting clients or professional work under the box numbers in the newspapers. Now, there would be cases of giving the public interviews. Now, here it would be permissible to give the public interviews, but it should not result into the publicity, or it should not highlight the professional attainments, and the details in the interview should be given only on the specific questions, and the information of factual nature only should be disclosed. So in short, it should not indicate the professional attainments, and it should not appear as the indirect solicitation of clients or professional business. There would be cases of publication of books, articles, or presentations. Now, in such cases, for books, articles, or presentations, the prefix CA or the designation chartered accountant and the name of firm is permitted to be mentioned. However, the professional attainments are not to be mentioned in such cases. There would be cases where there would be necessity of advertisements for celebrations on silver jubilee, etc. So, in such cases, the advertisements for silver jubilee, golden jubilee, diamond jubilee, platinum jubilee, or centenary celebrations of CA firms can be published in the newspaper. This relaxation has been given, taking into consideration the need for interpersonal socialization and relationships of members through such get-together occasions. About signboards. Now, with regard to the size of signboard, it is a matter which the member should exercise his own discretion and good taste. The use of glow signs or neon lights or large size boards which are used by traders or shopkeepers would not be proper. What should be kept in mind is there should be appropriate visibility of the signboard and there should be appropriate illumination of the signboard. A member can have name board at his place of residence and he can use the words chartered accountant, but he should not use the name of the firm on such name board put at his place of residence. There might be cases where the member's name appears in the public announcement with the details of directors. Now, in such cases, the use of expression chartered accountant is permissible. However, it needs to be ensured that description about his expertise, specialization, and knowledge in particular field are not published along with the name. The particular of directorships held by the member in other companies can be given, but the name of the firm of chartered accountants should not be given. So, reasonable care should be taken while mentioning the names of members in the public announcements with the details of directors. There might be cases of issue of newsletters. So it has been clarified that members in practice may issue newsletters on the issues of professional relevance, provided the firm name is not mentioned in the same. The prefix CA with the name of individual member is permissible. The professional services cannot be mentioned because that is governed by the advertisement guidelines of the institute. Now, there are cases like organizing training courses, seminars for the staff. So, organizing the training courses or seminars for clients, staff, and staff of other CAs is permissible, but it should be ensured that undue prominence should not be given to the name of the chartered accountant. So, in short, it should not look like solicitation of clients or business. Another situation arises about writing articles or letters to the press. So, members can write articles or letters to the press on the subjects connected with the profession and give their names and also use the words chartered accountant. Now, another area which is faced by the members is the publication of name of firm in the telephone directories or other directories published by the telephone authorities or by other private bodies. Now, it is permissible to mention the name of the firm or the name of chartered accountant in practice in the telephone directories or in such other directories with certain restrictions. Now, the publication should be only under the category of chartered accountants. The directory should mention the names in the same town where the member is located, and it should appear in the alphabetical order. Similarly, the name of the member should not be published in some differential manner or in some prominent manner. Also, the entries in that directory should be open to all the CAs or firms in that particular city where the directory is issued or published. So it's possible for the members to include their names in certain trades or social directories or certain specialized directories which have limited circulation, but with certain restrictions which we have seen. Now, what is permissible? What is the permissible activity in respect of certain advertisements? So advertisements for recruitment of staff in the member's own office, that is permissible. Advertisement inserted on behalf of the clients requiring the staff or wishing to acquire or dispose of business or property. So such types of advertisements on behalf of clients is permissible. Or there might be advertisement for sale of business or property by a member acting in the professional capacity as a trustee or liquidator or receiver. In such cases, the issue of advertisement is permissible. So we have covered many areas which have been described in the various guidelines issued by ICAI from time to time. Now there are certain announcement or clarifications given by the Ethical Standards Board of ICAI. We will see them in short. A CA firm may register on Udyog Aadhar web portal of the Ministry of MSMEs. It is not permissible for a member to use WhatsApp to send messages to make people aware about his practice and mention the services provided therein, because it will clearly amount to solicitation of work or solicitation of clients. It is permissible for 2 or more CAs in practice collectively to have a joint training session for their clients on GST and share the fees collected from the clients thereof. Now, another clarification. A CA in practice may be an equity research advisor, but he cannot publish retail report as it would amount to other business or occupation. And under clause 11, the member has to take specific permission of the council in case he wants to engage in any other occupation other than the practice of CA profession. A CA in practice may engage himself as registration authority for obtaining digital signatures for his clients. Now, we have seen already this, that it is not permissible for CA firm to print its vision and values behind the visiting cards, as it may result into solicitation and therefore not permissible. Similarly, it is not permissible for chartered accountants in practice to take agencies of UTI or GIC or NSDI. We have seen already the provisions relating to the members involved in teaching and other activities. We have also seen the clarification that it is not permissible for a member to mention himself as GST consultant. A member can share the GST updates mentioning himself as a CA with his individual name, provided the communication is limited to providing updates, and mention of CA firm is not permissible in such case. Now there are certain FAQs also published by ICAI. We would only see a few of them. We have already seen a few of them. The member in practice can mention his name along with prefix CA in a book or article published by him or on a presentation made by him. The name of the firm can be mentioned in the book or presentation. The name, the prefix CA and the name of the firm can be mentioned on presentation made either on the platform of the institute or against or on any other platform. Now, no mention should be made about the mobile number or contact details in case of the presentation or the books or the articles issued by the member. On the books, articles, or presentations, the firm name can be mentioned, but the names of other partners in the firm cannot be mentioned. We have already seen that use of logo or monogram of any kind, form, style is prohibited. Only the common CA logo can be used on the professional stationery. Yes. Whether it is permissible for a member in practice to write his own blog on all issues, whether professional or otherwise. Yes, it is permissible for members to write blogs. However, the contents of the blog should not be against the public policy, and the contents of the blog should not contain any matter that may bring disrepute to the profession. Similarly, the contents of the blog should not amount to solicitation of the professional work. Another clarification: whether a member in practice can earn income by way of royalty on books authored by him. So yes, since the authorship of book is generally permitted, the ancillary income or benefits received from the same would also be permissible. Now, another clarification in respect of acting as a DSA. So, it has been clarified the member in practice is not permitted to market any specific product. He may verify the credit card credentials, or he may provide services that are in the nature of verification, which are in the nature of assurance services. Thus, he can provide services which are of the nature of management consultancy and other services. But he is not permitted to market any products. Sorry, there was some technical problem. Okay. The clarification is in respect of use of designations other than the designation chartered accountant. We have already seen in detail the various provisions relating to this. Now, the last part, there have been various cases which have been decided in respect of the situations under the clause 6 and clause 7 of the part 1 of the first schedule. Now, the cases relate to various aspects which we have already seen earlier, where a chartered accountant sent application to the chairman of cooperative society offering himself for appointment as an auditor. This is direct solicitation, not permissible. There was another case where roving inquiries, that is, were made, like a CA wrote several letters to assistant registrars or registrars of cooperative societies, government of West Bengal, requesting for allotment of audit work and enroll his name on the various panels for auditors. This is making roving inquiries and was treated as punishable. Now, approaching through a third person, that is, bringing influence for getting the appointment as an auditor. HCA approached the principal of a secondary school through a third person known to the principal for his appointment as an auditor of that school. This was objectionable. Similarly, writing letters of change of address to non-clients, the member was found guilty for professional misconduct under clause 6 and 7 of the first schedule for having issued circular letter regarding change of address of his firms to persons who were not in professional relationship with him, and for having written letters to the shareholders thanking them for appointing him as auditor. So this was clearly treated as the violation of clauses 6 and 7. Advertisement of congratulations for opening an office. An advertisement was published in a newspaper containing the member's photograph, wherein he was congratulated on the occasion of opening ceremony of his office. This was treated as punishable. Advertisement seeking work from other professionals. A member gave advertisement in the newspaper seeking works from other professionals. We have seen that a member in practice can issue advertisement in the journal of the institute or newsletter of the institute requesting for work from another professional chartered accountants. Now, another case describing as liaisoning with the government departments, where a CA had sent letter to another firm of CA in which he had introduced his firm as pioneer in liaisoning with the central government ministries and the allied departments for getting various government clearances, etc. Now, this was treated as improper. Personal visit for securing appointment as an auditor, where a CA had visited personally the clients for securing the appointment as auditor. This is direct solicitation of client or work and hence was punishable. Writing letter for empanelment with a recommendation, where a CA had addressed a letter to the bank requesting for empanelment of his firm, showing experience, etc. And a member of parliament had also sent letter to the bank recommending the name of the CA firm for immediate empanelment as internal audit or inspection audit or management audit. This was treated as bringing influence for getting the audit work. Roving inquiries case we have already seen. Details of services and books written along with the New Year greetings. A CA sent New Year greeting cards bearing his name, qualifications, name and address of his firm, and also containing the names of the books in the greeting cards. And also he has mentioned to contact him for work of getting loans from banks or institutions or getting deposits. This was violation of clause 6 and 7. Publication of details in the souvenir. So one advertisement was given in the souvenir as with best compliments from so and so CA firm, with describing as share and stock sub-broker. And the advertisement also contained the office timing as 8 a.m. to 10 a.m. and also the telephone numbers of the office residents and of the market. This was treated as violation of clause 6. Using signboards on the electric poles and shutters of the shops. There was a case where the signboard of the firm was hanged on various electric poles and shutters of various shops. This was treated as violation of clause 6. There are various cases where there was violation of clause 7 in terms of using the designations other than chartered accountants, that using the words as management consultant or using the designation manager, liaison and sales, or using the words share and stock sub-broker along with the words chartered accountant. This was treated as violation of clause 7. Similarly, ACA had mentioned his experience as general manager of a cooperative bank and expressed himself as president and CEO of an institute in his professional documents, and had also depicted religion and politics in his letterheads and letters for professional attainments. This was considered as objectionable under clause 7. Advertising of professional attainments, like a CA wrote several letters to government department pointing out seniority of his firm, sending his life sketch and stating that he has glorious record of service to the country and to the organization of accounting profession for getting the audit work. This was again objectionable under clause 7. Offering concessions along with the services. So we have already seen this, that the charges for the services or even the nature of free of charge services cannot be advertised. Similarly, propagating the services through SMS, where a CA allegedly propagating his services subsequent to demonetization, an objective of government of eradicating the black money through mass SMS along with his mobile number, offering his services towards the conversion of cash with minimum tax liability. In such case, the member was treated as guilty under clause 7. So we have seen the various clauses, the explanation of those clauses, the various case laws decided under these clauses, and various opportunities available for advertising in the situation where normally the canvassing or advertising is normally not permissible. I think I have tried to cover the subject in detail. I would ask the coordinators to take the charge of this session. If there are any queries, I would answer the same.
Thank you, Shashikant Barve, sir. This is Ruta Chitare. On behalf of WIRC, I'll be conducting the last part of the session. So, Barve, sir, there are some questions which are coming up. Should I read them out for you, or you can read them in chat box?
Please, you can.
Sir, there's a question on, can we share greetings of various festivals and events on social media along with name of firm and contact details?
So I have already explained this is permissible so long as the greeting card use the word CA, chartered accountant, and the firm name, but the greeting card should not describe the nature of services offered, and the circulation should be restricted to the friends, relatives, and the clients.
Thank you. Any other question? Sir, I will ask from my side. There was one case which was reported about a person who was against, against whom the disciplinary action was taken because he displayed certain things on Facebook. Can you, if you have read about it, can you elaborate on that point?
I don't recollect having read the case which you are mentioning, but as I have said, the normal principles are there should not be solicitation of clients or of professional work. There should not be description of professional attainments. There should not be any content which should be indecent. There should not be any content which should be against the public policy, or there should not be any content which will bring disrepute either to the profession or to the institute. These would be normally the expectations on any sort of communications on any media.
Sir, a question there is there in the chat box about Google Maps and location about the firm. So can we display firm name on Google Maps since Google Map allows to mention name to enable easy search on address or Google pin. So can we enter the firm name?
I don't think there should be anything enable because it should not amount to advertisement and it should not amount to solicitation of work or solicitation of clients. Otherwise, normally details are allowed to be given even in the telephone directories or directories for special purposes or with limited circulation also. So personally, I don't think there should be any problem in giving that so long as it doesn't amount to advertisement in general.
There is a question about, now I'll be reading the questions from the question answer particular field. So can we post education or informative write-ups on professional networking sites like LinkedIn with firm name and email ID? So it's a professional networking site where whether we can share educational or informative write-ups, because this is one of the ways to say that, okay, I know about this particular thing. It is not exactly propagating, but what is the thin line?
See, I think what is permissible in case of books, articles, presentations, or even on appearing on the radio or any other media, the restriction is that you should not give your contact details. You can give the name of the, you can use the word CA, you can give your name, you can use the word chartered accountant, the firm name is permissible, but no mobile number or no contact address should be mentioned.
Sir, or email ID is not allowed? Mail ID?
No, it would be a contact address, so it would not be permissible.
So only name also should not be there, sir. If we are putting it on LinkedIn type social media, then naturally there would be a name.
There would be name, prefix CA, name, the use of chartered accountant, and the name of the firm with which you are associated. But there should not be contact details like mobile numbers or email IDs, address, no contact address, in short.
Not in the article, but it will be on the social media site where this is published. You understand? It's like Facebook. The name is there, and I'm putting something on Facebook. So
it should not look like describing professional attainments. If in
Oh,
any way it appears like professional attainments, I think it would be objectionable.
okay. Sir, there is another two questions here. I will now take two questions from the chat box, but I request the members to put it in the question answer field instead of chat box. Otherwise, it's very difficult for me to find out if I've left any question. So another question, can member in coaching class can be a chairman or treasurer in CA branch?
I don't think there should be anything objectionable for this purpose, both as far as the code of ethics is concerned, as far as CA Act or regulations are concerned, or even I think even as per the laws relating to the election, also I don't see any restrictions for the members engaged in any activities to be associated with elections. I think the members either in practice or even otherwise engaged in service or other activities also can contest the elections and can hold the offices as elected representatives.
Sir, I think to add to your point, we can say that as good governance, the people who are working in coaching classes may or may not take up activities related to students. Just from our own things, if we can do that. If I am teaching in some classes, I should not be involved in any students related activities. That's what I can suggest. Am I right?
It's a very thin line because it's a question of conflict of interest. Now, to what extent you want to stretch the conflict of interest concept is really to the best discretion of the member concerned. I think conflict of interest should be taken in very, very serious matter, and the members should make their own decisions. Legally, as I said, the ethical values far exceed the legal duties. So something may be legally permissible, but whether it is ethically permissible or not is a choice which individual member has to make that choice. He should ask his conscience or his heart and then decide whether he feels there is no conflict of interest. If he feels there is no conflict of interest, most importantly, what the third party feels, whether it is a conflict of interest or not. That is most important.
Okay. So next question is again related to publication on the website. Can a CA publish on website of a vendor, another vendor, stating that he is extremely satisfied with the product designed by the vendor and the product is very useful in his professional work? So there are many vendors, who give some kind of softwares for, say, project reports, for ledgers, accounting also. So can we as chartered accountants put on the vendor's website that, okay, I'm very happy with this vendor?
Are you issuing a report or are you issuing a certificate? If in your personal capacity, if you are writing something about your liking of a particular product, that is different. If you are using the name of the firm, in that case, you have to decide whether it is appropriate for the firm to issue such a certificate.
Sir, one more question is there. Can member issue article or post on social sites for knowledge purpose? I think we have done this question.
That is permissible. He should
Precaution is to be taken about names and contact details.
that should not
Yes.
contact details should not be there.
Yeah. Sir, last question, I think. Can a member put a video on YouTube, and what things are not to be posted while uploading video? Video on YouTube. Creating YouTube channel, when we create, what precautions are to be taken?
Yes.
Sub question to it. Can a CA firm also create YouTube channel, or a individual or partner can create?
See, what I think permitted is member or the firm can create web pages. Now, generally we have seen what are the restrictions. That is, even the educational videos are permissible to be circulated. In that case, as I said, name of the member can be given, but the name of the firm would not be mentioned. There would not be contents which would lead to a conclusion that it is a solicitation of the clients or business, and it should not give professional attainments, and it should not contain any material which is indecent or which is against the public policy or which will bring disrepute to the profession. Otherwise, I think writing the blogs by the members on any subject is permissible.
Okay.
And as far as firm is concerned, it is websites, so they can make websites.
Sir, it is about videos, that whether we can put on videos. YouTube channel is a separate case in itself, right? But I believe that if it's a pull mechanism only, we are not pushing the YouTube videos. I think that another precaution we can take, just as similar to websites, that we need not put the YouTube videos in place of people. If people want, they can search and then they can find out. Do you think that's okay?
Circulating educational videos, putting up blogs is permissible. But if something is an activity engaging in some other occupation other than the profession of chartered accountants, that would need a permission from the council. So if, I don't know, I will have to study exactly what is involved, but if that activity, any activity, if it is of a nature that it would mean engagement in other activity apart from the practice of chartered accountants, in that case, it would get covered by regulation 190A and it would need permission of the council.
Sir, another question. Can common letterhead or visiting card be printed by a member who is a CA and also insolvency professional and registered valuer? So IP and insolvency professional and also registered valuer. Can he print it on visiting card and common letterhead?
The word chartered accountants, insolvency professional, and registered valuers, these terms I think can be used on the professional stationery if the member is qualified simultaneously.
So we can use it in one common letterhead.
Only chartered accountants, insolvency professional, and registered valuer. These three I think are permissible. I can't hear you, man.
Can CA hold post on social organizations? Any permissions are required? There are various forums, right? So can a CA hold any positions like chairman, president, treasurer in other organizations other than CA?
See, there is regulation 19019A. Under that regulation, a member can engage himself in other occupations, and there are two categories. For certain occupations, there is a general permission of the council, and there are certain activities where special permission of the council is required. Now, for charitable organizations where there is no honorarium, in such cases, certain positions can be held in such public charitable institutions, which come under the general permissions of the council. But I think the member should refer to the specific annexure in respect of regulation 190A, and it specifies which classes are permissible and for which activities special prior permission of the council is required before engaging into such occupations. So I think the honorary office bearership of certain public charitable institutions, I think is permissible under the general permission level. But the exact, I don't have in front of me the regulation, but I think it is permissible under general permissions under regulation 190A.
Most popularly, it is about Rotary or Lions Club or certain such clubs where it is not exactly a charitable organization, but they are doing some different type of work. So I guess the question is more relevant in that sense. That
just give me 1 minute. see what is permission, what is permissible, permission granted generally. That is the appendix F to the book Code of Ethics, old Code of Ethics, and it says under clause 5, under clause 7, honorary office bearership of charitable, educational, or other non-commercial organizations. This is permissible under the category permissions generally granted under regulation 190A.
Thank
If it falls, whatever you are saying, organization, if it falls into this category as charitable, educational, or non-commercial organization, in that case, it should be permissible.
The person querying this, the querist wanted to talk about organizations like sports organizations, cultural organizations, honorary positions. So I think this query falls under that. Okay. Because it's a non-commercial organizations person. Okay. So thank you very much, Barve sir. I think all the queries are over. If anyone wants to put in a quick question, please do so. Otherwise, we will be closing the program. In between, people are asking the questions. Let me also tell the members that we are having 2 upcoming programs soon. One is on 13th and 14th May. There is a national conference on internal audit organized by Central Council. I mean, the national. It's a national conference, and we will be hosting it at WIRC. Also, we are having 2 more sessions. One is on 3rd and 4th of June. We are having regional conference at Pune. And of course, as you all are aware, the World Congress is also happening in the month of November. So with that, yes, there is no other question. So thank you very much, Barve sir. I think he has already left by some technical error. So thank you very much all of the participants for being here today with us. And any of the questions you have, please feel free to write to us at WIRC. Thank you very much on behalf of entire team at WIRC. Thank you. मिश्रा जी आप बंद कर सकते हैं.